Look at God in His glory. Greetings, YouTube family. Back again. Eternal Lamont L, also known as the Sagent. Sagent is a compound word, and the sage has been historically classified as the ones who know, and the agent is someone who conducts or transacts business on behalf of another. And I'm here transacting and conducting business on behalf of the Most High. With that being said, we're going to get right into it. Today, we're going to go over the issue of Corpus Delicti, which is Latin for the body of the crime, is what's needed for someone to have standing to come into court. So, mostly what we're going to go over today is about the body of the crime, Corpus Delicti, and how this removes you from any fictitious jurisdiction or any corporate jurisdiction. Because for a crime to be committed, there has to be an injured party. So, okay, who is the injured party? So let's look up Corpus Delicti. And this is coming out of Black's Law 4 Dictionary, as all my definitions will. Corpus, and this is Black's Law Dictionary 4th edition, page 413. Corpus, Latin, a body, an aggregate or a mass. Okay, aggregate means collective, more than one, or mass of men, laws, or articles. A physical substance, as distinguished from intellectual conception. The principal sum or capital, as distinguished from interest or income. The corpus. So, I know a lot of people probably didn't catch that, the aggregate or the mass, a corpus. So the corpus could be a body of people. Corpus could be a body of people. A corporate body politic, a body of people creates one body as a whole. So when most people come together, they're acting as one. So there we go. That's the basis of everything that's going to be discussed today. Corpus Delicti. Now, Corpus Delicti is specifically defined as, on the same page, Black's Law Dictionary 4th edition, page 413, Corpus Delicti, C-O-R-P-U-S-D-E-L-I-C-T-I, Corpus Delicti, the body of a crime. The body, the material substance upon which a crime has been committed, e.g., the corpse of a murdered man, the charred remains of a house burned down. In a derivative sense, okay, the substance or foundation of a crime, the substantial fact that a crime has been committed. Okay, so it's specifically telling us that there has to be a body of a crime, or there has to be a thing upon which an unlawful act was committed. If you walk up to a man and shoot him, he's the body of the crime. You shot his physical body. Okay, like they said, you burn somebody's house down. The charred house is the body of the crime. So now keep in mind, this is a 4th edition. This is an older book. So therefore, everything is in a constitutional context, not, according to legislative intent. So these are derived from older, bodies of law, the common law, corpus juris secundum. Okay, so the body of a crime. So we're talking about law, okay? Oh my goodness, I do. So we're talking about law, okay? And in the Constitution, it's 3 jurisdictions, and one of those jurisdictions are split into 2, right? So now you have law, which is common law, God's law, universal law, nature's law. Equity, and which is the balancing. It's the balance. It's the balance beam between the right conduct and fair transaction between the intercourse of people conducting contracts. Equity, okay, and it's based around unwritten principles, okay, and is based on fair dealing, okay. So that applies to men and human beings. And then you got maritime admiralty. So maritime admiralty is one and the same. So maritime is the law of the sea at a time of peace, and the admiralty is the law of the sea in a time of war. All right, so it's the same thing. It's just 2 sides to one coin. All right, so we're talking about real law, the body of the crime. So you got loved ones and people who've been locked up for victimless crimes. Yes, scamming, things of that nature. Probably, retail theft. Now, even though a human being uh, created or organized the LLC or corporation to conduct business out in the public in regards to its merchant affairs, it's a fictitious entity. So if you go and steal out of Walmart, indirectly, yes, you're causing the person who owns the fictitious entity loss, but not directly, because the entity that's bringing action against you in the court is Walmart. I cannot injure Walmart because Walmart cannot attain parity with me. Someone, a living human being, is going to have to move on behalf of Walmart. Get what I'm saying? It's a victimless crime because you do have the right to face your accuser. So that directly ties into what? Standing. Okay, and standing is a principle of law. Check one of my reference affidavits. Okay. Now, standing consists of two absolutely essential elements. One, violation of legal right. Two, personal injury. Personal injury. Neither one without the other is sufficient. Both are required. So, they got one of them. Okay, a violation of a legal right. And so by going to steal from a public entity, you violated that public entity's legal right to conducting commerce without being deprived of any of its products or being caused loss to. Fictitious entities have certain privileges and benefits in which they claim as rights. They use them synonymously, but remember, they're different. So they got you on that violation of a legal right, but they don't have you on personal injury. Why? Because Walmart cannot come and testify against you. It's a fictitious entity. Okay? So, who is injured if no first-hand competent fact witness files a complaint? Who has a legal right to tell me I have injured another if no first-hand competent fact witness has signed a complaint of injury? It is not sufficient for the plaintiff to state I have injured another or that the defendant violated the law. So, when I was 18 years old, I was locked up for delivery of controlled substance containing cocaine, right? Yeah, I was hustling when I was younger, owed me some money. And so now, in that field of work, you deal with low vibration people. Scum of the earth, as some people will call them, okay? But you scum of the earth right along with the people because this is who you're attracting into your life. I wish I knew that then, but it doesn't matter now. So, these people, they go out, they strung out off drugs and things of that nature, and they have habits which they need to take care of or want to take care of. So what do? Anything, by any means, I'm going to obtain whatever I'm trying to use to take my mind off the fact that I'm poor, I'm homeless, I steal, I'm hungry. The list goes on. So when these people get in trouble, they're like little weasels. They're like little rats and mice, and they go to the store and get caught stealing. Something simple. You stole the Snickers. You was hungry. You got caught. Oh, what are you doing with this pipe in your bag, sir? Oh, no, just smoke a little. Yeah, we tested this positive for crack. You smoke crack. Oh, we could take you to jail for this. Yeah, I know. I just don't want to go to jail. Well, tell us who gave it to you, and we'll let you go. That's it. There you go. Guess what he's going to do? He's going to wire up. He's going to come back to you and get you. All right, now you got it. Now, 9 months later, once they're ready to sweep up everybody, your name comes out on an indictment list. Oh, hey, bro, did you hear your name was on the indictment list? I'm like, shit, me? How? Oh, they got me up there on the news. Okay, let me go look at the news. There I go. On the news, channel 2. Okay, I got indicted for a substance containing cocaine. Okay, allegedly. All right, now, not knowing anything, I go into the dismal crypt and I sit. I don't know anything. You have these public pretenders coming in here acting like they care. Hey, look, this is what we're going to do for you. Oh, they breath reeks of coffee and cheap suits and bullshit cologne and penny loafers. Like real penny loafers. and mismatched suits. It's terrible. It's terrible. So they come in there, they say, hey man, we're gonna get something worked out for you so we can get you home as soon as possible. They pretend to care, no. But you realize that they're an officer of the court. So he's here to turn you over to who? The court. Okay? Now, you get in there and they give you a piece of paper, says indictment on it. On this day, such and such, John Doe was charged with delivery of a controlled substance containing cocaine. Okay, the state of Illinois is the plaintiff. All right. But it says one of the sheriffs who works in the paperwork department of the county building, who takes the charges and charges them, it says he or she charges that on this day you sold X amount of grams to CI and it was recovered and the marked money was recovered from you. Okay, cool. All right. Now, we already got two people right there. The state of Illinois is bringing action, but the officer in the county building charged the complaint. But the affidavit, which led to the information, was made from the officer who conducted the buy in the field. There go three people now. Now, this officer writes an affidavit saying, you committed such act on this day with his confidential informant. Now, here goes the confidential informant. Because they're the one that brought all this to you to get out of the hot seat for his petty retail theft. Boom. So who is the victim? Who is the accuser? Is it the strung out crackhead? Is it the officer who conducted the buy on you? Is it the officer who charged the instrument? Or is it the state of whoever? Who is the accuser? So that leads you to ask more questions. How do you have standing? If you know these principles, you have tools. You have weapons to defend yourself with. Standing is legally defined as the position of a person in relation to his capacity to act in a particular instance. Okay, so we know the crackhead ain't got standing. Now, the officer has standing according to his corporate rules in his corporate jurisdiction to conduct this transaction in order to get you, but he doesn't have standing to bring a complaint against you. So he's out. Now, you have the officer who charges the instrument and sent it upstairs to bring it in court. Okay, they have standing to do that because that was their job, but they didn't have standing to bring an action against you because you didn't injure them. Remember, this is all about the Corpus Delicti, the injured party. So you didn't injure the crackhead. You didn't injure the police who conducted the buy. You didn't injure the officer who charged the instrument. And now, once you get into you, then we've been through four people. Now it says the state of Illinois versus John Doe. So what did I do to the state of Illinois? Or you broke the laws of the state of Illinois. In order for me to be bound to any obligation of any law, I have to have what? Contracted with this entity. You need to know this in your head. So when you get in the state, sir, bring up the next person. Okay, 2021 CF 10369,008,000,002. Because they at work. Oh yeah, they're at work. State of Illinois versus John Doe. Come bring them up here. Your Honor, Mr. Doe here has been charged with delivery of controlled substance containing cocaine. All right, well, sir, let us admonish you. This, that, and the other. You're facing this, possibly this. How do you plead? And here we go. Done. Not guilty. So you just made yourself the surety. But hey, that's not the subject of discussion. So 9 times out of 10, guess what they're doing? They sharing sheet. They offer you something on the first go around. I hear guys come back. Look, man, I'm gonna take my first thing I can, smoke it out of here, and I'm gonna just go on take this little time. Hey, you never consider like fighting this? You never consider defending yourself? What if I punch you in your shit right now? Are you gonna consider defending yourself? Okay, it's the same thing. So, what's the state's offer? Well, Your Honor, the state is prepared to offer Mr. John Doe here 3 years at 50%. With the 2-year conditional release. Well, John Doe, do you accept that offer? Oh, no. All right, then. Well, we won't settle this here today. We'll continue for 6 months. We'll see you later. If you sit in jail, they're gonna drag you out. So let me go back to that word right there. Because what happens when we go into court? What do they ask us? What's the state's offer? What does offer mean? Offer means to bring to or before, to present for acceptance or rejection, to hold out or proffer, to make a proposal to exhibit something that may be taken or received or not. Black's Law Dictionary, 4th edition, page 1233. That's an offer. These sound like contractual terms to me. Okay, so a contract is a promissory agreement between two or more persons that creates, modifies, or destroys a legal relation. What's the legal relation? You don't become into a relationship with the state until you agree or accept their offer. Acceptance. Let's see what Black's Law Dictionary has to say about this. Acceptance, the taking and receiving of anything in good part as it were a tacit agreement. Go back to my last video. We discussed tacit agreement. Tacit means, hey, you stole my noodles. You're not going to say nothing? All right, you agree. Tacit means shied away from. Tacit means not direct. Tacit means passive. Tacit means non-assertive. Tacit means quiet. Or in our terms, you bitched up. Tacit admission, okay? Agreement to a preceding act, which might have been defeated or avoided if such acceptance had not been made. Oh my goodness, they telling you. You might have defeated that, you accepted it. Everybody knows when you take a plea agreement, you waive all defenses known and unknown. All right? That's why we use conditional acceptances and private administrative remedies. All right? So, the act of a person to whom which a thing is offered or tendered by intention of retaining it, such intention being evidenced by a sufficient act. So, the state offers you 3 years at 50%, and you do what? Accept it. Yeah, I'm cool with that. I'll be home in a year and a half. If I do a drug program, I'll be home in 9 months. I'm going to just go down there and lift weights and eat a whole bunch of oatmeal and noodles. Dumbass. Now, offer, acceptance. Offer, acceptance, okay, sounds like a contract. A promissory agreement between two or more persons that creates or modifies or destroys a legal relation. Now, you have express and implied. Okay, they don't express the contract until you sign the plea agreement. But your actions all the way through the course of the proceedings over 1 year, 2 years, 3 years implied that you were going to contract with them ultimately. And once they drop the plea agreement, what do they have you do? Sign it. Express and implied. An express contract is an actual agreement of the parties, the terms which are openly uttered or declared at the time of making it, being stated in distinct and explicit language, either orally or in writing. Okay? So if you downtown in Times Square in New York, Manhattan, and you whistle for a taxi, you come board his vessel, you're implying to him that you're going to pay him for a ride. Because you don't pay when you get in. That's a contract. That was implicated by your actions. Or you can say it to them orally. But they express the contract by way of a plea agreement. Agreement is another word for contract. Is another word for contract. And what did I say? So what do we use? They use a quasi-contract. That's what they're using, a quasi. In the civil law, a contractual relation arising out of a transaction between the parties which give them mutual rights and obligations, but do not involve a specific express convention or agreement between them. So that sounds like a finesse to me. Quasi means finesse. They finna finesse your dumb ass. Quasi, remember that. So now, this is what we do as American nationals. We wish to remain in honor. We wish to settle this. We know that we're not tacit, we're assertive. We're not passive aggressive or aggressive. We're not bullying people, but we're not getting bullied. You right there in the middle, you assertive. You're not letting nobody step to you on any type of level without defending yourself from an adverse action, right? So to remain in honor, to let them know that we have overstanding of contracts, we conditionally accept their offer. Now, according to Black's Law Dictionary, 4th edition, page 394, a conditional contract is an executory contract, the performance of which depends upon a condition. It is not simply an executory contract, since the latter, which means the second option, the former is the first, may be in an absolute agreement to do or not to do something, but it is a contract whose very existence and performance depend upon a contingency. A contingency. So, this is our private administrative remedy. We conditionally accept what you have to offer us. So, in order to stay in honor, we let the state's attorney know, hey, we're here to, settle this. I'll take whatever offer you have to give me, contingent upon you proving this. So, we'll have administrative process here, okay? This has been sent off. But this is a private communication between the parties, all right? It's a private communication between the parties. And guess what? You put teeth on them. You send it through a notary, all right? That's your witness. And your second witness is who? The male. You can't lie and say you didn't get my paperwork. This is our contract. Now, we send him this first notice. This is our notice of conditional acceptance. Then, what is he going to do? He's going to remain silent. Uh-oh. What's that word again? Tacit? Come here, little kitty cat. Tacit. And so, in this tacit admission, we're going to approach equity with clean hands. We're going to give him another chance. We know due to impossibility, negligence, or some mistake, man, your dog ate the paperwork. You probably didn't get it. So, we're going to be the nationals we are. And then send him his notice of non-acceptance. An opportunity to cure. Okay? Now, we're just going to give him a little bit less of time on that one. Okay? So, with that being said, we sent you 2 notices with the same thing in it. And we asked you, based upon your proof of claim, you prove this, and I'll accept the maximum. But you've been quiet. And where obligation or duty is imposed on one to respond, which is a public servant, when the people ask questions, you are bound to answer, because that's the oath you took. All right? And your silence can only be equated to fraud, dishonesty. All right? Then what do we do last? We certify your non-response. Okay? This is certified through a notary. So, you know that you won't be able to testify on your own behalf, especially depending on the status of your straw man. Maybe a felon, So, they're going to say, oh, he's not a credible witness. I might not be, but this notary is. And so is the post office. All right? So, what did we learn? We learned that in order for somebody to have standing in court, that the Supreme Court says the requirement of standing, however, has a core component derived directly from the Constitution. Okay, let's go on. A plaintiff must allege personal injury fairly traceable to the defendant's allegedly wrongful conduct and likely to be redressed by the requested relief. Now, all right. So, with that being said, let's read that backwards. Because in order for you to navigate through the treacherous waters and confusion of the Wizard of Oz, this is Never Never Land that you're going to, it is detrimental that you understand to know principles of law when you're seeing them, because nobody's going to stop and say, hey, the principle of what's being said is this. The reason that the powers of the police from this agency, and this agency apply to you is because of the penumbra doctrine in law, which are implied powers that snowball and give other people powers indirectly by the power vested in the original person who created the agency. No, nobody's going to tell you that. So, by way of you going down to the airport and walking through it, you indirectly gave the federal government contract, and they give the Federal Aviation Association authority to assess civil penalties upon people who violate the rules and the statutes and the almighty commandments of the fictitious entity known as the United States government. All right? Nobody's going to tell you that. So you have to see. Let's read it backwards. Okay. Likely to be redressed by the request of relief. Okay. Boom. Now, here's the second one. A plaintiff must allege personal injury fairly traceable to the defendant's allegedly wrongful conduct. The fairly traceable to the defendant's alleged wrongful conduct, okay, that is called causation. I had to talk to myself. You got causation. So causation is the causal connection between one's conduct and another's injury. I have to stir it up. It'd be right there on the dial plate sometimes. You got to rearrange some things. And then you have personal injury. So those are the three things. One must allege personal injury, the actual injury, the gunshot wound. The causal connection between one person's conduct and another's. And okay. Yeah, those are the three. The causal connection between one's conduct and another's injury. Okay, that's the causation. So the causation was, okay, the causal connection is, boom, one man physically moved his finger to squeeze the mechanism, which is called a trigger, that the primer hit the pin of the bullet, discharged the projectile towards his human body, entered his body, flew out of his body, maybe caused a fatal injury, maybe it didn't. That's the causal connection between the shooter's conduct and the gunshot victim's wound. The pull of the trigger. All right? And redressability. If that person brings this action before a court, the likelihood of him winning is 90% or above. Just in general. Okay? My hair look crazy. Time for a haircut. Now, that's standing. That's standing. So when you got the state of ha bringing the action against you, how did they have standing? How did you injure a piece of paper known as the state of who? Because we've said it time and time again, these courts are a figment of our imagination, a fiction of the mind only, and they can only concern themselves with fictitious entities and the contracts between them. So who are they contracting with in order to attain parity with you? Your straw man, your birth certificate, your social security number, you're a public person. That's why you need to update your status for and on the record. And this is not meant to be construed as legal advice. If you seek legal advice, find yourself a competent counselor and be advised. This is for information and educational purposes only and entertainment. So, yeah, with that being said, you have to see and know what's going on without being told this is what's going on. They do not have standing. Okay? They do not have standing. So, as a secured party and creditor, you're creating a distinction between this fiction that they're trying to attain parity with, and you, the living man. You're aggrieved. An aggrieved man is a man who's resentful towards someone doing wrong towards him. Sir, in order for you to adjudicate me, I must be able to confront my accuser. You know what? You're already in default. So the paperwork and the contract is final, but I'm going to give you another chance right here, right now. And this is going to put the icing on the cake. I'll take whatever offer that you're willing to give me, or whatever, even the max. If you can bring an injured party before the court. If not, you're perpetrating fraud upon this court, and I won't be held responsible for it. Because I look over this way when I'm speaking to the state's attorney. He's the one that brought it in here. I'm not talking to the judge, because if he gets to talking too much, he's practicing law from the bench, and then he's guilty of a high misdemeanor. Oh, I'm going to enter a plea for you. No, you're not. Now you're acting as an unsolicited attorney. You can't do that. Now, you have no standing to do that. Where's the contract between you and I, where I gave you authority to enter a plea on behalf of the defendant? And I say defendant because the defendant is the fiction. I'm not the defendant. I'm here as a third-party intervener on behalf of and to conduct business for as the authorized representative of the defendant. I'm here to make my exemption principle. So I've made my exemption principle because I have accepted for value all these charges returning from discharge, settlement, and closure. Just that simple, sir. Now I'm gonna need settlement, and I need to see the adjustment of the account in the balance. So they're not gonna do that. So as a national, understand when it's time to jump in the ring, you gotta fight. But like myself, you use tactics. When I go into court, sir, I see it's a lot of business to be conducted here today, and what I have here is it needs to be dealt with thoroughly. So I'll voluntarily wait for you to finish with everybody, so we can, me and the attorney can finish our agreement. Is that okay? That's okay. Okay, yeah, for sure. Because guess what's gonna happen? You in the middle of a slaughterhouse while they shearing sheep, and you know what's going on. You finna wake up somebody. Hey man, come on, man. Hey man, come on, man. Hey, get him up out of here, man. That's what they're gonna do, sir. Have you been mentally evaluated? Oh, I'm compos mentis. I'm mentally sound, sir. I dictate that. Huh? That's what they're gonna do. Now, another term that's applied to this is consideration. This is how you know these are quasi contracts, finesse contracts. Because in order for a contract to be lawfully binding, there has to be consideration given from somebody. And there's only consideration, there's never no consideration given. Okay, so like when these guys get signed to these labels, and the consideration is the advance, the $1 million advance. Here goes $1 million. This is our consideration for you signing with us, if you didn't know what consideration was. But let's see what Black's Law Dictionary, 4th edition, page 378 has to say about consideration. And a technical term indicating that a tribunal has heard and judicially determined matters submitted to it. That is consideration, but that's not in regards to what we're dealing with today. So we're going to go to contract. The inducement to a contract. The cause, motive, price, or impelling influence which induces a contracting party to enter into a contract. So you offering me time to go sit as a surety for a debt while my body gets older in prison, the most invaluable commodity I have, which is my time. Where's the consideration in that? Mr. John Doe, we're willing to offer you $1 million to go sit in jail for a year. You know what? I might consider that, because a lot of times the average people out here nowadays don't make $1 million in a year. Only 1% of black men make over $400,000 a year. Me right now, as a national, I would consider taking $1 million to go sit in jail for a year. And I sitting there like it never happened. But now, you're making it sweet for me. That sounds like a contract to me. Yeah, I need you to deposit that before I go do my first day. Yeah, I'm gone. But you were given no consideration. So it's a quasi-contract, and it's a unilateral contract, because guess who's the only person who signed it? You. So therefore, if any violation or breach of contract comes, the other offering party, which is the state of BS, they're not liable for anything. They just sit back and wait for you to mess up. Like your driver's license contract, it's unilateral. You signed it. We didn't say if you did this, we'll be liable for this, that, the other. You signed the driver's license contract. So guess what? You're the only one liable for violating the rules and terms of the contract. You went speeding down the street, you violated your contract. 30 miles and over, you violated your contract. Huh? I'm a national. So when I did go at a sensitive time in my life, didn't know any better, I went and got it, but I contracted under my terms and conditions. And what's my terms and conditions? My terms and conditions is UCC 1-308. Please go, you can look it up for the ones who don't know what the UCC 1-308 is. Okay? UCC 1-308. Reserve your rights. Huh? Reserve your rights. So, my in general comprehension of UCC 1-308 is I will not be bound to accept or be compelled to perform on the obligations of a contract which I did not knowingly enter. That's my comprehension of UCC 1308. So now I'm going to read it directly from their law. It's called, and the UCC is the Uniform Commercial Code 1-308. Okay. Performance or acceptance under reservation of rights. UCC 1-308, performance or acceptance under reservation of rights. So now you can contract, but now you know how to protect yourself. This is how we learn how to protect ourselves. What does A say? A party with explicit reservation of right performs or promises performance or assents to performance in a manner demanded or offered by other parties does not thereby prejudice the rights reserved, such words as without prejudice or under protest or the like are sufficient. Okay? So what happens? I'm a CEO of a multi-million-dollar company and I go get a loan from my company, but I just signed my name on the paper. Okay? John Doe. All right? Sign my signature. Don't something look wrong there? You just signed your name and it just looks wrong to me. I mean, because I know now. So if you, on behalf of your multi-million-dollar company, went and got a multi-million-dollar loan and you signed your name like that, and you didn't reserve your rights or make known your position in regards to who you're transacting business for, just know. Maybe you can even guess who just became liable for that multi-million-dollar loan if you default. Not enough time. You, my guy. Bring your ass here. Now, this is a powerful word. By. The word by lets them know that you're evidencing your agency in relation to ABC LLC. John Doe Trust. When your lawyer draws up the paperwork for you, or if he signs the plea agreement for you, he's going to say, by Deceptive Serpent, Esquire at law, on behalf of the dumbass defendant. Yeah, he can sign your contracts for you, but he's evidencing his agency in regards to you because he knows how to not go sit in jail. So, now, you evidence your agency. John Doe. Now, what they say, like words are sufficient without without prejudice. Now, a lot of times, this is going to draw their attention because they'll be like, oh, huh? Because they know what that means. They know you're trying to protect yourself. Now, me personally, I don't put without prejudice. It takes up too much space, and it's usually not that enough space to do that, so I sign like this. Okay? This is how you sign. John Doe. All right? There you go. When you sign anything, and especially if you don't know what's going on, that's how you should be signing. Now, if you were signing on behalf of an LLC or a company, you would put your position, CEO, CFO. For us as nationals, since they're trying to administer our trust, we're as a third-party intervener and an authorized who? Representative of who? The defendant. Your trust. Now, you're evidencing your agency. What's your agency? You're the authorized representative on behalf of who? Your trust, your straw man, your public person. And according to my signature, I do not wish to be bound, and I reserve my right to not be bound to the obligations or performance of a contract that I did not knowingly or willingly enter, free of stress, threat, duress, or coercion. Stop just signing shit. As soon as y'all get in there, they give you sign this. No, I'm not signing nothing. I'm not signing anything. When I go on court, they make little slick comments. Oh, he's a sovereign. He don't sign papers. Hey, man, I'm sovereign by existence. You can mock me all you want to, but you know that I know. And I don't say this. It's just for you to know. Excuse me. My eyes open. All right? Protect yourself. And therefore, you reserve your remedy. You reserve your remedy by sounding like this. Don't ever sound like this. You can sound like this. You can sound like this. And depending on who you are and what role you play towards your fiction, you let it be known right up under there. This is who I am. I will not be held liable. I will not be held liable. Okay. Let's see. Okay. Now, let's go over to, let's see what the Uniform Commercial Code has to say about instruments assigned for accommodation. Okay. And this is UCC 3-419, instruments signed for accommodation. Now we're going to skip down to, and now keep in mind when you read this, you have to stop and go look up what the word means in the law dictionary, because there's going to be several words, of course, across the section that you read that you don't know. Don't think that you know, because you don't. Okay? You don't. Go look it up. Okay, Section D. And so listen, they can't get around this because it's in their law. Section D, UCC 3-419. And we're going to scroll up to Section D. All right? Well, what does that say? If the signature of a party to an instrument is accompanied by the words indicating unambiguously, and unambiguously means it can't be misconstrued. Ambiguous means that it can. That the party is guaranteeing collection rather than paying of the obligations of another party to the instrument, the signer is obliged to pay the amount due. Okay, on the instrument to a person entitled to enforce the instrument only if execution of judgment against the other party has been returned unsatisfied. The other party is insolvent or insolvency proceeding. The other party cannot be served with the process, or is otherwise apparent that payment cannot be obtained from the other party. See? So, if the signature of a party to an instrument is accompanied by words indicating that the party guarantees payment. So even though you didn't put it, you remember it's assumed. You're guaranteeing payment because you didn't what? You did not accompany your signature with words indicating unambiguously that you're not going to be held reliable for it. That's how you signed it. You didn't put, see, this unambiguously lets them know who I am and who I'm acting as and how I reserve my rights. You can't misconstrue that. You can misconstrue this. Yeah. You can misconstrue that. Yeah. Let's go to the 3. All right. Now, UCC 3-41, signature. A person is not liable on the instrument unless, 1, the person signed the instrument, okay, or the person is represented by an agent or representative who signed the instrument, and the signature is binding on the represented person. You are the represented person. Your attorney signed for you. So the agreement is binding on you. Okay, a person, he's not liable on the instrument. The person is represented by an agent, and representative who signed the instrument, and the signature is binding on the represented. So, this signature is binding on who? The represented person. I'm the authorized representative. Who am I representing? My public fiction, my straw man. By me, the living man, on behalf of, authorized representative on behalf of. I'm not binding myself to surety. So therefore, I'm nulling your claim. You can't get past that. And guess what they're going to do? They're going to try to get past that. And guess what you're going to do? You're going to stand on your square. And guess what you're not going to do? You're not going to back down. You won't be pushed into a corner. And you won't be forced to go sit in a cell. Because now you know. Huh? Now you know. The Corpus Delicti. All that stemmed from what? The body of the crime. All of this stemmed from the body of the crime. If there's no body of the crime, there's no crime. Period. Get that through your head. Traffic court, there is no crime. Traffic infractions are not crime. They tried to offer me a Class A misdemeanor criminal conviction for speeding 30 miles and over. No, traffic infractions are not crimes. Update, hello. Victim, jaywalking is not a crime. Who did you harm? You not wearing your seatbelt is not a crime. We know what crimes are. You know that if you drive drunk, that's just as bad as committing crime. So that can be equated to crime because the effects of your actions can hinder or harm someone. Stealing from another human is a crime. Murdering, raping, maiming, those are crimes. Coveting your neighbor's possessions, his wife, that's a crime. Hatred in your heart, that's a crime. That's a crime. But all these victimless statutes and codes, and those are not crimes. Corpus Delicti. There has to be an injured party, and that person has to have standing. That's it. Stop going in here playing these people games. Gird up your loins like a man. So, that being said, Corpus Delicti. Standing in law. This what it is. None of this is meant to be construed as legal advice. It's for information, educational, and entertainment purposes only. So, click subscribe to my channel. I'll be putting out content on a regular basis. Click and subscribe to my channel, The Sagent. Once again, I'm Turner Lamont L. Also known as The Sagent. If you find any of this information in this video useful, please contact me. If you wish to have a consultation or have any questions, time is money. So I'm very reasonable, and also any processes that you're inquiring about, we can work anything out. The email is in the description, sagent@gmail.com. Contact me if you have any questions, but I do not offer legal advice, and it's for information, educational, and entertainment purposes only. So use this information at your own risk. Once again, I'm Turner Lamont L, also known as The Sagent.